Welcome everybody to UCL Laws. It is my absolute pleasure as Dean of the faculty to welcome you to this inaugural lecture. The professorial inaugural lecture is a rite of passage, and it's one that we take very seriously at UCL. Not every faculty has an inaugural lecture for all its professors, but we do. It's an opportunity for a new professor to inform a wider audience about their field of expertise and their research program. But it's more a moment to recognise, and tonight we recognise Ilanah, recognise the new professor, and to celebrate the very significant achievement of the promotion to Professor of Law. And that moment of celebration is is what I really want to emphasise. We don't often in academia stop and celebrate the work that we do and perform so hard to achieve in academic life. We are usually in the business of critique and challenge and questioning, which is all very important. But this evening is a real academic pleasure. Welcome, Robin. Very important that you're here. Over her career to date, Professor Fhima has steadily built a very strong foundation as an expert in the law of trademarks, as you will hear more about in a moment from our distinguished chair. Ilanah has published widely in the field of trademark law. She has also introduced real teaching innovation around IP courses to students and to those in practice, and she has engaged with external IP agencies around the world with her research. In the faculty, Ilanah is at the centre of IBL, which I'm sure many of you in the audience know. She was been here since the very beginning of IBL, and is now one of its co-directors, along with Matt Fisher, who I can see in the front row, and Sir Robin Jacob, who's up the back. And it is a globally renowned institute of IP, or brand and innovation law, as it is officially known. We are all in the faculty very proud of IBL and the work that it does, and that is part of Ilanah's contribution and ongoing legacy. So the faculty is absolutely delighted this evening to celebrate all of these achievements. It's my job, because it's such an important evening, I introduce the chair, who then introduces Ilanah. So this is part of the theatre of the inaugural lecture. So Sir Richard Arnold, who is our chair, Justice Arnold, was called to the bar of England and Wales in 1985. He has a very distinguished judicial career. This began after practicing at the bar. He then became chairman of the Code of Practice for the Promotion of Animal Medicines Committee and appointed person hearing trademark appeals from 2003 to 2008. So at that point, I think the alignment of interests with Ilanah becomes obvious. A deputy High Court judge from 2004, then a judge of the High Court Chancery Division from 2008, a judge in charge of the Patents Court in 2013. He's been an external member of the enlarged Board of Appeal for the European Patent Office since March 2016 and has been a judge of the Court of Appeal since October 2019. Now, I have introduced some distinguished judicial guests in my time, but that is a very, very long list of judicial appointments. And in addition to that distinguished judicial career, there's all the writing that Justice Arnold has done in IP law, as an editor of Dicey, Morris and Collins as well on the conflict of laws. He is a visiting professor at the University of Westminster, an honorary doctor of laws from that institution, and a distinguished judicial visitor at UCL Laws. So it's my great pleasure to introduce Justice Arnold, to introduce Professor Fhima.
Thank you very much, Eloise, for that kind introduction. Well, having known Ilanah Fhima for nearly 20 years now, which is quite something to think about, it's a great honour and pleasure for me to be here to help celebrate, after the event, as is the usual course, her appointment as Professor of Intellectual Property Law at UCL and our inaugural lecture this evening. She, of course, is very familiar to this institution because this is where she started as an undergraduate a little while ago now, and then a master's student. And then for some reason, she spent some time at Brunel. Can't imagine why. But she wasn't there long because she was back in 2007 and has remained here ever since. Now, over that time, she has established herself as unquestionably one of the leading commentators on trademark law, not only in the United Kingdom, but throughout Europe. And her key contribution to the field has been in the elucidation and analysis of principles of trademark infringement, which have been under-examined prior to her input. This, of course, is crucial because what is a trademark, and in particular a registered trademark after all, but a right to stop others, a negative right to stop infringement. And so the scope of protection affording to trademarks is crucial, as is the way in which the interests of trademark owners and competitors are balanced. And these are topics with which Professor Fhima has engaged over a substantial period of time. She's probably best known for her two monographs. Firstly, her solo monograph, Trademark Dilution in the United States and the European Union, examining that difficult topic, which continues to vex us to this day. And then more recently, Likelihood of Confusion in European Trademark Law, co-written with Dev Ganji from the University of Oxford. She has also written many articles, and it's not appropriate for me to read out the list, but I will mention four briefly. First of all, The Essential Function in Trademark, looking at the Court of Justice of the European Union's use of free movement of goods principles in determining trademark law. Secondly, the role of legitimacy in trademark. Thirdly, the prize-winning The Public Interest in European Trademark Law. And most recently, particularly pertinent to this evening, is her Consumer Value as a Key to European Trademark, published last year in the Modern Law Review, looking at the use of branding theory as a key to propose a single rationalized basis for functionality exclusions. The other point I would briefly like to highlight before handing over to Professor Fhima is her particular interest in and work on empirical studies of trademark infringement. This is something that was pioneered in the USA, but Ilanah was the first to apply the empirical methodology to European trademark jurisprudence. And this is something which I think is going to be of growing importance in the field. Tonight, she's going to address us on the subject of 3D shape marks. This, of course, is also a great area of interest in the field and something where her elucidation is greatly needed. So, Ilanah, over to you.
Thank you. Thank you, Richard. Before I start, maybe I can begin with a few thank yous. First of all, thank you very much to Richard for that very generous introduction, and also for being so unstinting with your time, both for IBL and for the many other academic institutions that you support. It's really very appreciated. Second, Shimon, my husband, currently driving somewhere with a car full of kiddies. Thank you for being my partner and my teammate in everything we do. Alexander, Nathanael, Khani, Racheli, and of course Lizzie, thank you for always keeping me on my toes and taking such an interest in Mummy's trademarks. And I managed to get the football stadium in. I even got Kai de Wolf in, but the dolls will have to wait for the written paper. Kat, our wonderful events manager, thank you for your tremendous efforts in organising the event tonight, and also Lisa for organising so many IBL activities. Nothing is ever too much trouble for our event team. Lynn, thank you for going above and beyond in everything you do for IBL, and also to support me in my research and my teaching, and especially for whipping my slides into shape tonight. Colleagues at UCL, particularly Robin, Matt and Alina, and also colleagues in the wider IP community, thank you for creating such a supportive and stimulating environment in which to teach and research. Mum and Dad are no longer with us, unfortunately, but they always supported me in all of my work and always encouraged me to do just one more degree, just in case. Also to the Faculty of Laws at UCL, thank you for creating a place where people's individual needs really do thrive and really are considered, and in particular, very precious for me and I think many colleagues, a place where it's possible to both be a parent and to thrive academically. And one final sort of thought to express, if you'll allow me my Gary Lineker moment. As the granddaughter of refugees who came to the UK under duress, I would really like to express a hope that as a country we will always welcome those fleeing persecution and allow them, as my family have done, to contribute to our great and fundamentally tolerant society. But onto the more prosaic matter of trademark law. In this presentation, I'm going to be conducting a 360-degree analysis of three-dimensional shape marks. I'll be looking at which marks are registered, which marks are refused registration, why they are registered or refused registration, and what lessons we might learn from this research. So first of all, an introduction to shape marks. All types of marks can be registered in the EU, and this includes shape marks. But there are some special considerations for shape marks. In particular, there is a risk of monopolising product characteristics that other traders need in order to compete. So in particular, if you're registering the shape of a product, you will capture the characteristics of that product, and this may block other competitors from being able to use them. Second, there is a problem of a potential overlap with existing time-limited intellectual property rights. The subject matter of three-dimensional trademarks will often be something that could be protected by design law and possibly even patent law. Now, these rights are rights which are limited in time. Trademarks, as long as you keep paying your renewal fees, are something that can last forever. And finally, there is a problem with consumer perception. Consumers are not necessarily used to seeing the shape of products in particular as something which indicates trade origin, and therefore they don't necessarily see them as something which acts as a trademark. In response to this, the way in which we interpret the absolute grounds for the refusal of registration are slightly different, I think, for shape marks and other forms of mark. First of all, no mark can be registered if it lacks distinctiveness. However, the Court of Justice in its Henkel case has sort of put in place a sort of special standard that applies to trademarks, arguably a stricter standard that says that when trademarks shape marks can only be registered where they depart significantly from the norms in the sector concerned. However, this ground for refusal can be overcome if it's possible to show that consumers recognise shape as a trademark because it has acquired distinctiveness. Now, acquired distinctiveness does not work to overcome the problems posed by functionality. While distinctiveness focuses on consumer perception, functionality focuses on the needs of competitors. And there are particular grounds on which the needs of competitors are considered. First of all, shape cannot be registered if it's necessary to achieve a technical result, if it adds substantial value to the goods, and also if it is a shape resulting from the nature of the goods. Now, the academic view on the registrability of shape marks is that it is really very difficult, almost impossible. I'm going to sort of cite two academics who I respect greatly, but who on this instance I disagree with ever so slightly. First of all, Leben, writing in 2020, said that it's almost impossible to register a shape mark. Shape marks are likely to be devoid of distinctive character, and not just product marks, but marks of packaging instead, unless they will only be registered if they have acquired distinctive character. Kerr says it's a mystery how it's possible really to work out which shape marks can be registered, and that it will only be those exceptional lucky shape marks that are neither too plain or too splendid to be accorded inherent distinctiveness. I think this position is very understandable. If you look at the way that the CJEU in particular has described the process that you need to go through in order to register a shape mark, then it does make it look like it's very strict and almost impossible. However, in doing the research that I've done previously on shape marks, I've done research on functionality, I've also done some empirical analysis on the grounds for refusal of registration for Estelle's empirical book. And what I saw when I did this work was that actually there were shape marks on the register. They were there, and they weren't there on the basis of acquired distinctiveness. So I wanted to delve deeper and actually work out what was being registered and what was not being registered. So my hypothesis was it's not as difficult to register a shape mark as people think. And to do this, I wanted to work out which types of shape marks were being filed before the EUIPO and what the outcomes were. I wanted to understand which aspects of shape marks made them more likely to be registered, or indeed more likely to be refused. And I wanted to understand whether it's just possible to register the shapes of packaging, or whether it's also possible to register marks for products as well. Because most of the sort of exceptional examples of registered marks that I'd seen tended to be marks for packaging. The other thing I wanted to investigate was acquired distinctiveness. I had seen very little evidence of acquired distinctiveness being used to support shape mark applications or indeed registrations, and I wanted to put this though on an empirical basis. Finally, when I was looking at functionality, what I tended to see was that actually there weren't an awful lot of functionality cases at all. It's a bit annoying if you're trying to do research on functionality because all the cases tended to be about distinctiveness. So what I wanted to understand is, again, on a quantitative basis, how many or how often was functionality really being used? Was it being used to protect competitive concerns? And also, how did it overlap with distinctiveness? Now, in terms of context, I write against a background of actually a growing body of work on the empirical analysis of trademarks. What I hope this contribution of this work is to look in a bit more detail about non-traditional marks and to understand not just those which are being refused, but also those which are being registered, and to understand the reasons behind this. Now, moving on to the specifics of my research. First of all, methodology. I focused on the shape marks registered before the EUIPO. The reason I chose this geographical area is they have really quite excellent data available. If you look at the EUIPO database, you can have access to the all of the marks which have ever been filed before the EUIPO and their prosecution history. And it's also really very easily searchable. So it really lent itself to this research. You can't quite do that with the UK data at the moment. The UK IPO have actually kindly provided me with some data, which hopefully will make it into the final version of the paper. But for this, the focus was on the EU IPO. I looked at all shape marks that have been registered in the 5-year period from 2017 to 2021. I chose this period because I didn't want to go too far back and miss out on the sort of more recent case developments. But also, if you do anything too immediate, then you actually find that there's no data and that all of the marks that you're trying to look at are pending. So that's not hugely useful. I chose 3D shape marks as my criterion. The only sort of weakness of this, and I don't think it's something that's particularly easy to surmount, is you capture those marks which the applicant has classified as a 3-dimensional mark. You don't capture what Ganji has identified, which is that there are certain figurative marks where the applicant has tried or succeeded in registering this thing as a 3-dimensional mark, but actually it shows the shape of a product. I'm not really sure, to be honest, what you can do about that other than trawl through and visually inspect all of those figurative marks, which I think is a project for another day. So I found that there were 2,024 shape marks applied for during my 5-year period. This, though, is slightly misleading because what you find when you sort of start reading the file histories is that some of those marks are registered for a range of goods and are registered for some goods and refused for those goods, but they get recorded as registered marks. So I'd split those records into two, and I took the refused element of them and described them as partial refusals. I coded this data in Excel. I coded various aspects of it, characteristics of the marks and grounds for objection. I then took my data, I analysed it in SPSS statistical software. I used mostly descriptive statistics, tracking frequencies and also doing some cross-tabulation between different factors, and in one case, a regression analysis. I then took this data back into Excel with the aim of making some pretty pictures that we will hopefully look at tonight. So first of all, or before we start, I've divided my results into two. First are mark characteristics, and the second section will look at reasons for refusal. In looking at the marks, for sort of brevity reasons, I'm going to focus on like the two paradigm kind of marks that actually encapsulate products that we might look at. So on the one hand, we have our shape of a product in black and white with no non-three-dimensional additional distinguishing criterion. At the other end, we have our colour mark for packaging with additional non-three-dimensional material that will often be distinctive in its own right. And we will be tracking these two examples of marks as we go through the data. First, which marks are being registered and how many of them are being registered. So, of my 2024 marks, 1,462 of them were registered. So that's how many registered shape marks there were in that 5-year period. That was a lot. That was more than I expected, I have to say. Yet, at the same time, one has to keep it in proportion. And actually, there were 610,399 EU trademarks registered in that period. So the shape marks make 0.2% of all EU trademarks registered in that 5-year period. They also had a lower acceptance rate, a higher refusal rate than other forms of EU trademarks. So EU trademarks were registered, 90% of the applications were registered. This went down to 72% for shape marks. This was still lower, but again, more than perhaps I expected. Now, which type of marks were registered? So we can see a breakdown of the types of marks. This is kind of my characterization of those marks. The EUIPO doesn't do that, this as such. I'll focus particularly on product and packaging marks. There were more applications for packaging than there were for products, but still a good number for products as well. But we can see that applications for packaging were significantly more successful with an 80% registration rate than those for products, where that was only 55%. The other thing you'll notice if you look towards the right hand of the chart is that there were registrations for things that I wasn't necessarily expecting, so logos, services and other kinds of marks. And we'll look now in a little bit more details at that. So I was surprised to see that there were 52 logos there recorded as three-dimensional marks. I think what's happened is people have characterized these logos as three-dimensional often because they have kind of shading in them. To be honest, not much rests on that. It was a bit of a quirk, but it's nonetheless there. More significant, I think, were the 6% of shape marks registered for services. Now, I'd rather assumed that shapes are tangible things, and therefore shapes will be registered for tangible things. And services, of course, are not tangible. However, this was not the case. And in particular, one thing that I noticed was that shapes of products were being registered in relation to the service where they would be used for the services claimed. We'll give some examples in a minute. But I think there is potentially an issue here. When I say issue, I really mean a problem, Because if you look at the functionality grounds do not seem to envisage a possibility of functionality being raised in relation to services. So the functionality grounds talk about the shape or other characteristic of the goods, i.e. the goods and not the services. Now, both the EFTA in the Vigeland case and the EUIPO guidelines suggest that functionality does not apply to services. But I think this is problematic, and this is why. On the left-hand side, you can see this rather attractive cappuccino inside an ice cream cone. And now I'm sure we could all do with one of those, but I think our ability to access them may have been limited in this case. So this mark, which actually was in 2016, but I think it illustrates the point so nicely that I've kept it in here. But this mark was refused for coffees and coffee beverages. However, it was allowed for coffee shop services. And yet what this would seem to do would be, if I were the owner of this trademark, I would be rather objecting if any other coffee shop tried to serve a cappuccino inside an ice cream cone. On the right-hand side, we have this nice hut thing registered for temporary accommodation services. Once again, if I were the owner of this trademark, I would be objecting if anybody else tried to offer temporary accommodation services with similar huts. And what troubles me here is I think that these marks are potentially something that can be used to block competitors from providing a service, or at least the optimal service in this instance. Another example is the shape of a Land Rover. Now it's got this nice little Land Rover badge on it, so maybe not such a problem if it's registered for cars. However, if as indeed it is, it's registered for repair services, this would seem to limit the ability of competitors to be able to communicate that they repair these Land Rovers, or at least to communicate using the imagery of the Land Rover car. Another thing that I found problematic in competition terms was that a number of my marks, which I had categorised as other, were in fact shapes of products that have been refused registration for the product depicted in the mark, but allowed to be registered for other allied products. So here we have the shape of a Renault car, refused for cars and remote control cars, but allowed for other forms of toys. We have the shape of a baby bottle, refused for baby bottles, but allowed for beverages and packaging. Likewise, we have the shape of a camper van, refused for vehicles, but registered for pretty much every other kind of vehicle that you can think of, including shopping trolleys, but not for camper vans. Now, once again, if I were the owner of these trademarks, I think the risk that there is that subsequently they could potentially be used to block the very goods for which they were refused registration. So to give you an example, this baby bottle, if it was, it has been refused registration for baby bottles, but the registration is there for beverages. Now, I think it could be argued in the future that if a third party used this mark for baby bottles, it could be argued that this that the use for baby bottles was confusingly similar in the sense that it is complementary to the beverages for which it is registered. So I think these marks could in the future be used to block access to the very marks for which they, the very goods rather, for which they have been refused. And I'll make some suggestions about this later. Next, we see not all marks are equal. So in all of the charts that I have, things in red or pink or yellow are bad news for trademark applicants. Red's refusal, the pink is partial refusal, the yellow is withdrawals. So what we see is that while 72% of while 72% of marks were registered, the registration rate was considerably lower for products at 55% than it was for packaging. Next, looking at the impact of colour. So once again, colour gives differential results. So the number of applications wasn't hugely different. 1,077 colour marks versus 947 black and white marks. However, the success rate was quite different. So 81% of colour applications were registered, but only 63% of black and white applications were registered. Next, the importance of non-three-dimensional matter. This was actually a slight surprise to me. Perhaps it shouldn't have been as much of a surprise to me as it was, but I think what surprises me is the extent. So what I'm talking about is that there are very many shape marks which are not just shape marks, but combinations of shape and non-shape material. I've given you the example of these rather attractive alcoholic drinks, which are all registered individually as shape marks. What we see is that while what we're looking at is shape marks, most of the marks are shape plus non-shape matter marks. So even at the application stage, only 38% of our applications for shape marks are for sort of pure shape marks. Most of them are shape plus. But even and then when by the time we get to the registration stage, we see that only 25% are sort of pure shape marks. I'm not saying that this is good or bad, but I think it's a phenomenon worth noting. And if you look at the registration rate, what we see is that the success rate, the registration rate for for marks including non-three-dimensional matter is 87% compared to just 47% for our pure shape marks. Now, putting all of this data together to try to understand which characteristics of marks will actually most likely lead to registration. First thing I did was conducted a regression analysis. What one is doing with a regression analysis is you're looking for a particular outcome. My outcome that I was looking for was registration as a trademark, and you're trying to quantify the contribution made by each factor to the possibility of registration. For various boring reasons, you need a significance rating of 0.005 or less, because I think there's a relatively limited amount of data. 2,000 marks is a lot for a trademark lawyer, but not really much for a statistician. Then what this meant was that quite a lot of my factors actually didn't reach that significance rating. But here are the ones that did, plus one that is a near miss, which I thought I might get away with talking about. So the first thing to note is the contribution of non-three-dimensional elements. So if a shape mark has non-shape elements, then it is 10 times more likely to be registered than those which have no non-shape elements. Next, a mark which I categorised as other, and this includes all those ones where you have a product registered for goods other than the product depicted in the mark, was 3 times more likely to be registered than other forms of trademark. A mark in colour was almost 1.5 times more likely to be registered than black and white marks. And finally, a mark for a product was significantly less likely to be registered than other forms of three-dimensional trademarks. Now, I also put these factors together. What I saw was that different combinations of mark factors led to very different outcomes. And in particular, I was very interested to know, can you really register a pure shape mark? When I say a pure shape mark, I mean a black and white mark for a product with no non-three-dimensional material. And the answer I found was you can. It's hard, but it's possible, or harder. So here is my fearsome chart. My fearsome chart gives us all of the different kind of combinations of type of mark, whether in colour or black and white, and whether the non-three-dimensional material was included or not. And what we see, not surprisingly, that of the ones which actually embody what a consumer might experience in terms of goods, so products and packaging, we have an 87% registration rate for packaging in colour with non-three-dimensional material, so a kind of moist, detailed mark. However, we only have well, I say only, but we have a 27% registration rate for products in black and white with no non-three-dimensional material. And I sort of have mixed feelings about this in the sense that it's clearly a lot harder to register this kind of mark, but it is possible. There are these pure shape marks there. And just another way of breaking down this data, we see that 6% of our registered EU trademarks are these kind of pure product marks. Now, does this matter? Sometimes I think maybe it doesn't matter. If this is the sort of thing that's being registered, this rather nice towel holder. Sometimes it matters more though. So we have this spoon registered for table cutlery, this rubber toothbrush thing registered for pet dental care, and the shape of a van registered for vehicles. So really things which would seem very much to embody the product that we are looking at. Moving on to the second part of my results, grounds, and this looked at grounds for refusal. Why were shape marks being refused registration? First question I asked myself is, which grounds are being raised most often? In my naivety, I think before I started doing this sort of research, I rather suspected that because functionality was put there to kind of counter the special dangers posed by shape marks, even though it's no longer limited to shape marks nowadays, I thought that the thing that would be raised most often in relation to a shape mark was functionality. This, however, was not the case. So what we can see is how often an objection based on the relative grounds, not the relative grounds, but the grounds for the refusal of registration was raised. And what we see is that the key ground which is kind of raised as an objection to shape marks is lack of distinctiveness, which was raised in 22% of shape mark applications. Functionality, on the other hand, wasn't raised particularly often at all. So for second indent, technical functionality was raised in just 2% of shape mark applications. And this equated to 34 actual cases. The third indent was raised in just 1% of our shape mark applications. Now, what happened to these grounds? First, I think the trend that we see is in a way quite similar, that the kind of key bulwark against over-competitive or perhaps overreaching shape marks is again lack of distinctiveness. The red areas are those which are bad news for trademark applicants, and we see that if you look at the rate of refusal and the rate of partial refusal, once a lack of distinctiveness is raised, then 82% of shape marks were refused or partially refused on that basis. This is significantly more than successful objections based on technical functionality, the second indent, where 68% were similarly successful, or the third indent, where it was 72%. Ignore the first indent because there was only one case raised under the first indent, so we can't really get too much meaningful data out of that one. Looking at lack of distinctiveness, looking specifically at different types of trademarks, again, we see differential impact, perhaps not surprisingly. So lack of distinctiveness was raised in 62% of our sort of black and white product marks with no indicia, but in only 3% of packaging marks in colour with indicia. Now, technical functionality. Because there were not many technical functionality cases at all, what this meant was that actually very few of any category of mark had technical functionality raised. This was at 5% for our pure product marks, really quite a bit lower than I was expecting. So most of our pure product marks, the black and white marks with no indicia for products, were just not being considered as to whether or not they were functional. Moving on to substantial value, what we see is this ground was raised even less. Interestingly, the place where it was raised most often was in relation to black and white packaging with no indicia. And to be honest, I was quite surprised by how infrequently substantial value was raised. I thought there were a considerable number of cases for things which were quite aesthetic, which were just not challenged on this ground. Now, I know substantial value isn't limited to marks which are aesthetic, but once you have a mark which seems to be particularly aesthetic, it's surprising, I think, if this is not raised. So here are some examples where the objection was raised, which I think are all fair enough. But here are some examples where it wasn't raised, in particular the shape of a chair for furniture, the shape of a thing with a snake around it for brooches, and these rather attractive bottle shapes. And to me, this suggests something is perhaps going a bit wrong. If not that substantial value isn't being found, that's perhaps a matter of discretion, but the fact that substantial value just is not being raised in these sorts of cases and is not being considered. Finally, in terms of results, acquired distinctiveness. Now, as we've said, the kind of conventional wisdom is that acquired distinctiveness is required for shape marks to be registered. And Annemiette has gone even further and said that actually the system as it is encourages people to invest in acquiring distinctiveness. And maybe this isn't actually a great use of funds because it's basically getting them to invest in marketing rather than more useful things. I'm not sure that the figures bear this out. So the red area is those where acquired distinctiveness was not raised. The green area is those where it was. Acquired distinctiveness was raised in just 71 of my 2,137 sort of cases. And acquired distinctiveness was found in only 8 of those cases, not 8%, but 8. So really a vanishingly small impact for acquired distinctiveness. Now, I think the reason for this is that acquired distinctiveness has to be shown across the entire EU. Brangba has explained in some detail how this is a very difficult standard to reach. I find this problematic because acquired distinctiveness is most definitely in there in the legislation, and yet it has been pitched at a standard which cannot be achieved. I do wonder, though, if perhaps this is easier to show in relation to a single trademark in a single jurisdiction. We shall see. Now, to finish off, what lessons can we learn from this research? First lesson is something that hopefully you've gathered, that there is a diverse universe of three-dimensional shape marks registered in Europe. Yes, you can register a shape mark in the EUIPO, and not just on the basis of acquired distinctiveness. And while the registration rate is perhaps lower than other forms of marks, it's still pretty high. And also that we can see that it is possible to register these pure product marks, the black and white marks with non-three-dimensional material for products. Next, just how important non-three-dimensional matter is. Like we said, 75% of our registered shape marks aren't just shape marks, but they have other things. I think this raises questions about scope of protection, both for applicants and for people enforcing marks. First of all, for applicants, I do wonder how useful some of these shape marks are. You have these very detailed shape marks, which are being sort of registered almost in a sequence. Like, for example, those bottles that we looked at of the alcoholic drinks, which was about 10 very similar three-dimensional shape marks, each being registered. Now, there may be other reasons for wanting to register these marks. I'm not sure that the shape mark actually gives too much more than marks to do with the labelling, etc., or the word mark would do. But perhaps like having the get-up registered might provide some kind of protection against counterfeiting on a national level or something like that. So that's from the owner's point of view. From the point of view of, I think, when these marks are enforced, I think we really need to be quite careful with these marks, that it is, in fact, the distinctive element of that mark that is protected and not the non-distinctive underlying element of the shape mark that is being protected. The other thing I would say on this is, one thing I saw is that so many of the marks that I was looking at were marks for get-up. And I don't think we necessarily quite think enough about Get Up in Europe as a sort of separate category with separate needs. Yes, clearly Get Up can be registered. It is on the register. As I think Robin will tell us, it's been on the register for years. But just thinking about it itself is something that we haven't necessarily done so much. Next are shape marks for services. We identified that there was potentially a problem here and the potential to block the delivery of services. And yet these services marks are being registered with a 91% registration rate. I've argued that this is a competitive problem, and I've some suggestions for perhaps how we could counter some of these problems. One suggestion is to look at the wording of the legislation and read that of goods as a minimum standard. As we all know, there's precedent for some creative reading of the wording of the directive. This might be one where it would be a good idea. So that would be to say that the fact that it talks about the other characteristics of the goods doesn't exclude you from thinking about services as well. In this brave post-Brexit world, we potentially have the possibility of changing the wording of the Trademarks Act to include services. But either way, I think this is a subject that needs a little bit more thinking. Next, the overlap between technical functionality and distinctiveness. What we see is that technical functionality is barely ever raised, and it's distinctiveness that's really doing the legwork in protecting the overreaching of three-dimensional trademarks. In fact, I think where it is raised, it's normally raised in conjunction with distinctiveness. I think I came across, I think it was only 8 cases where functionality was raised on its own without reference to distinctiveness. Does this matter? In a way, it doesn't matter. In terms of outcome, I'm not sure that it matters, in the sense that distinctiveness actually is delivering some quite robust protection against the overreaching of shape marks. It's being raised, as we said, in 22% of shape mark cases, and where it is raised, it is very bad news for the trademark applicant. Having said that, I think with my academics hat on, it troubles me that we are not having those discussions about the needs of competitors. Distinctiveness is all about consumer perception. The interests which are protected by functionality are not being articulated, or not being articulated explicitly anyway. So that troubles me about distinctiveness doing all the running here. One thing I think that would probably trouble a lot of people is that for lack of distinctiveness can be overcome by acquired distinctiveness, whereas functionality cannot, and therefore it's perhaps a problem if we kind of sideline functionality. In principle, I agree, but on the numbers that I found, I'm not sure this really is actually the thing that's making a difference here, because there are so few inherent distinctiveness cases where acquired distinctiveness would displace that initial finding. Just one suggestion for how we could potentially refocus on functionality if we wanted to. A very simple solution would be to go back to what the court in Phillips and Remington said should be happening, which would be that you look at functionality first before you look at distinctiveness. Now, Ramirez-Montes has conducted research and given some very detailed reasons why it is that this actually hasn't happened. But at the same time, if we wanted to go down that route, there is a kind of a quick and easy way of doing it, although I think it also brings its other problems because of the difficulties of examining for functionality compared to examining for distinctiveness. I think the overlap between substantial value and distinctiveness is more of a problem. So I think we said that, or we did say that distinctiveness and functionality are actually quite aligned in terms of outcomes. That's not necessarily the case with substantial value. The difficulty is that Leben and Kerr and possibly others have identified, which is that in order for a mark to be distinctive, it has to depart from the norm in the sector. And yet, departing from the norm in the sector is exactly what adds substantial value, or what's seen as adding substantial value to the goods. Yet I think we have a problem because of all these marks, these aesthetic marks, which are not being objected to. What I would suggest we do actually is maybe step away from the Henkel test here. I think the Henkel test is causing us problems. I don't believe that there is actually as much of a misalignment as it looks like. I don't believe that the marks that we looked at would really necessarily be identified as indicative of origin by consumers. Because they have that primary aesthetic meaning, I think this would be the primary meaning that consumers would take as well. But I think hands are tied from actually adopting that position, because the Henkel test says, well, this is different from all the other nice bottle shapes which are out there, and therefore this is something which we should treat as inherently distinctive. Blocking registrations, so those marks for other products that we saw, so where it's being registered for products other than the product depicted in the mark. What I would like to see here is a more nuanced examination. I think when marks are examined, it's almost sort of compartmentalised, and perhaps it doesn't need to be. So when you have, for example, the mark for the baby bottle, when it is being examined to see if it is distinctive for beverages, I think it would not be a bad idea if there was also some consideration of the fact that it had been refused for bottles. If this can't happen at the registration stage, another option might be, when these marks are being enforced, to actually look at these file histories and to see if there is an attempt to enforce the mark against the very goods for which it has been refused registration. This should be something that is not treated, not looked upon kindly. Finally, one thing that didn't actually come out in my empirical data, but is something that I quite like to highlight, is our overlap issue. So what I saw actually is quite a lot of three-dimensional marks for product configurations, often ranges of product configurations, sometimes 30 or more products made by a single company as trademarks, which could very easily have been potentially registered as designs. I think these are being registered on the basis of their name or logo, as Common Practice 9 actually says should be happening, that if you put a non-distinctive shape plus distinctive non-three-dimensional material, this is something that is registerable. Now, no one is doing anything wrong here. There is nothing to stop you from registering the subject matter of a design as a trademark. But kind of looking from outside the system, I think we should be thinking more about this overlap with designs and thinking about why it is that applicants are perhaps choosing both, or in very many instances are actually choosing three-dimensional trademark protection instead of design law. So here are some examples. This is one of a range of items of furniture registered by the Gubby company. You can't really see it very often, very well, but really a range of furniture, all of it with this either Gubby name or a little fish logo on it. These nice UGG sandals with the word UGG on it, presumably pulling it through to trademark registration, and these Regina Seduce Me sandals, which, and it happens of these examples, it's just that one on the right-hand side that actually has parallel registered design protection as well. And just to finish off, a few of my favourite trademarks that I didn't get to look at, but hopefully will make it through to the written paper. Thank you very much.
So, this being an inaugural lecture, I'm afraid you lot don't get the chance to ask questions. There's no Q&A. However, as chair, I have the privilege and prerogative of commenting. So I will comment briefly as follows. What we've seen tonight is a demonstration of the power and value of the empirical method in elucidating how the trademark system really functions. Some of what Ilanah has revealed to us, I think, would come as no surprise to anybody who's familiar with the case law. So, for example, it comes as no surprise that functionality objections are so rarely raised. Why is that no surprise? Answer, because of what happened when the Court of Justice decided on the KitKat reference that I referred to them, and they told us you can't combine the functionality objections. So you've got to block the entirety of the application with just one, and even if combining 2 or 3 would block it, you can't do that. So that obviously made it much more difficult to rely upon functionality. Again, it's not too surprising that acquired distinctiveness is so hard given what happened in the parallel case, the Mondelez case, which came up from the EUIPO, also concerning the KitKat shape. And that confirmed that you needed to acquire distinctiveness across the entire EU. One of the interesting things, of course, is what about the reference, which should have resulted in a raising of the standard of acquired distinctiveness even in one country, let alone across the EU. I don't see much sign of that having really happened, but that's perhaps a space to watch. So some of what we've seen is perhaps to be expected, but some of what we've seen I think is quite surprising. It was certainly a surprise to me to learn that there are shape marks registered for services. Wow, who knew? I certainly didn't, and that's very interesting. I also find it quite interesting what we have been told about this small role being played by the objection of substantial value. One might have thought after the B&O cases, where, if you remember, the B&O loudspeaker was refused, not on the ground of distinctiveness. It passed that because it was said, well, that was a substantial departure from the norms of the sector. But then for almost exactly the same reason, it was refused on the grounds of substantial value. Now, of course, many of you will remember that second decision got quite widely criticised, and it would seem that the EUIPO has rather taken that criticism to heart, and maybe for that reason is not raising that objection so often. But query whether that's actually the right answer. Anyway, plenty of food for thought for all of us. That's enough from me. Time for drinks.
So I now have the great honour of performing the ritual, which is to formally inaugurate you as a professor. So on behalf of the Faculty of Laws, I, the Dean, now formally inaugurate you, Ilanah Fhima, as Professor of Intellectual Property Law in the Faculty of Laws. Thank you. Thank you, Ilanah. Fantastic and really interesting.